Thank you. Good morning and welcome. The Committee on Health, Land, Justice, and Culture is now called to order. Today's Tuesday, September 20, 2022. Can we keep the door closed? It's really loud out there. Okay, thank you. So in compliance with the open government law, notices for this public hearing were published in the Guam Daily Post on Tuesday, September 13th and Friday, September 16th, 2022. They were also posted to the Government of Guam public notice portal and live streamed via the Guam Legislature's YouTube channel. Notices were also disseminated via email to all senators and all main media broadcasting outlets. Individuals testifying shall first be recognized by the chair before speaking and begin by stating their name for record-keeping purposes. There's one agenda item for this morning, that is Bill number 334-36 COR, introduced by myself, Therese M. Terlaje. It's an act to add a new Article 3A to Chapter 1, Division 1 of Title 26 Guam Administrative Rules and Regulations relative to the adoption of rules and regulations for child placement agencies. I'd like to thank my colleagues for joining this morning, beginning with Senator Terlaje, Senator Mary Torres, Vice Speaker Tina Muñoz-Barnes, Senator Ada, and Senator Joanne Brown. I think Senator Rigel's also joined us, but all right, so we will begin with a statement from the sponsor. Since this is myself, I will start out with just introducing the bill in general. So in Public Law 36-68, there was a mandate set forth which required the Department of Public Health and Social Services to promulgate rules and regulations for all child placement agencies, setting the minimum standards governing the granting, revocation, refusal, and suspension of licenses for a child placement agency and the operation of a child placement agency within 180 days, in order to require the licensure of any child placement agency operating in Guam. That public law also required Public Health to transmit the rules and regulations to the Legislative Committee with subject matter jurisdiction, and that such rules and regulations shall be exempt from the provisions of the Administrative Adjudication Law, provided that at least one public hearing is held by the Legislative Committee with subject matter jurisdiction. Quote, to ensure transparency, permit public participation therein, and provide a method of making rules readily accessible to the public, unquote. Public Law 36-68 further mandated that no rule shall be effective until after a legislature in Guam, by passage of a bill that is enacted into law, approves, disapproves, or amends any rule. So Bill number 334-36 COR was introduced to adopt these rules and regulations for child placement agencies. These rules were transmitted to us by the Department of Public Health and Social Services, transmitted to the legislature, and referred to my committee just recently. I'm trying to find the date, but I don't have that in front of me, sorry. So we did put this on again as a priority item so that we can have a public hearing on the rules and that they can become effective on the interim. However, I did put in the bill that I created to adopt these interim rules, that they would actually be also act as the permanent rules until further amended by the Department of Public Health and Social Services pursuant to the AAA process, the Administrative Adjudication Law. And that way, Public Health would be able to have hearings on its bills and go through the regular process if it intends to amend this in any way. The rules and regulations for child placement agencies are crucial. Adoption agencies are currently licensed through the Department of Revenue and Taxation without standard eligibility requirements and regulatory controls and the law set by the Department of Public Health. Furthermore, there are bills that have been passed into law that authorize independent adoption agencies to play key roles in the foster placement and adoption of newborns and children prior to these rules and regulations for these agencies. Public Law 36-39, which was Bill 108, authorized licensed adoption agencies to act where previously only the Department of Public Health and Social Services was authorized. There was great concern that these actions are without scrutiny of CPS or the Bureau of Social Services at the Department of Public Health and Social Services. So these include that a child is placed in an adoptive home by social service. The changes to the law include that a child is placed in an adoptive home by social services or a Guam licensed adoption agency. Supervision of a child living in an adoptive home under the guidance of social services or a Guam licensed adoption agency. A representative from an independent Guam licensed adoption agency may be a member of the Adoption Screening Committee, responsible for reviewing adoption applications and selecting adoptive parents for each child legally available for adoption and/or given up to social services for placement. The public law allows for a newborn child to be taken by an adoption agency representative to a pre-approved adoptive home or temporary shelter care home until permanent placement occurs, where the law used to allow the natural parent's caseworker to place child in a previously arranged foster home, and that's a caseworker through public health, if adoptive home has not yet been selected. The prior law allows adoption agencies to place a child in a proposed adoptive home where prior law allowed only for the Division of Social Services this authority. Public Law 36-40 expanded the Newborn Infant Safe Haven Act to include 911 service providers and adoption agencies in the chain of custody for infants relinquished under the Newborn Infant Safe Haven Act. So for the record, in addition to stakeholders, invitations to provide feedback were sent to the Department of Public Health and Social Services, its new Division of Children's Wellness, and to the Department of Revenue and Taxation, and of course to adoption agencies on Guam. We will now accept testimony from those on the panel. So we'll begin with the Department of Public Health and Social Services. Please begin.
Hi. Hafa day, everyone. Buenas and Hafa day. Honorable Therese M. Terlaje, Speaker of the 36th Guam Legislature and the Committee Chairperson on Health, Land, Justice, and Culture, along with Vice Speaker Tina Muna Barnes, Senator Tello Taitagui, Senator Clint Rogel, Senator Tony Atta, Senator Joanne Brown, and Senator Mary Torres. Thank you for this opportunity to provide testimony on Bill number 334-36, an act to add a new Article 3A to Chapter 1, Division 1 of Title 26, Guam Administrative Rules and Regulations relative to the adoption of rules and regulations for child placement agencies. The Department of Public Health and Social Services is in support of Bill 334-36, as it will authorize DPH-SS, Bureau of Social Services Administration, Home Evaluation and Placement Services Section to license and monitor the compliance of child placing agencies. My name is Crisinda Uggan, and I am the Human Services Program Administrator with the Bureau of Social Services Administration, or BOSA. Joining me is Crystal Gooden, Social Services Supervisor 2, and Mayfei Moiko, Social Services Supervisor 1, for the Home Evaluation and Placement Services Section, otherwise known as HEPS, who collaborated in creating the rules and regulations currently before you. We look forward to implementing these rules and regulations, which will set the minimum standard for the governing, granting, revocation, refusal, and suspension of licenses regarding the operation of adoption agencies on Guam. We recognize that our next step is to develop the additional regulations for foster care and therapeutic foster care providers, which are also required to provide to you, the legislature. As the goal of adoption is very different from that of foster care, The requirements providers of foster care services must meet are also different. Therefore, DPHSS will develop separate regulations that address the unique requirement of each type of placement. We thank you for your time and look forward to continued collaboration to solidify our processes and to indemnify proper execution of our rules and regulations as proposed. Si Duas maasi para tori tampun mizu pago, sa tori biran mizu para ifamaguanta. Si Duas maasi. Thank you.
Thank you, Administrator Uggan. Congratulations on this new position. And thank you also for being here to Crystal Gooden and Mayfei Muko. All right, we'll now hear from Bethany Taylor, Harvest House.
Hafaday, thank you, 36 Guam Legislature, for me being able to be present today. Honestly, I am here as support to you to answer any questions that you might have as a citizen of Guam. I have adopted out of the foster care system 2 times, as well as have 4 foster children that are up for adoption. So that would make a total of 6 kids adopted out of foster care. So with that being said, I'm here to answer questions on that, as well as I've been in the foster care system now for 13 years on Guam, so I have helped and mentored many foster families that have adopted out of the foster care system, as well as being the executive director of Harvest House. I want to be very clear in the rules and regulations that are being presented and how it affects our organization, Harvest House. For our main purpose and goal on Guam is to recruit, train, and retain foster families, which is a very big endeavor on Guam, much needed endeavor on Guam. And we are not an adoption agency at all, yet we do recruit those families to foster who end up sometimes adopting. And so I just want to have that clarity as the rules and regulations are being addressed and how it would affect our organization, as well as just really be very clear in allowing you to be able to answer or ask questions that might be very specific to a foster family adopting or how an adoption may happen on Guam. So that's just where I come from. Thank you so much for allowing me to be present.
Thank you so much for being here today to answer questions and for all your work, of course. Si Duas Masi. All right, so just some housekeeping. So we did, of course, request a fiscal note. We have not yet received one from BBMR. And we had also invited the Department of Revenue and Taxation to be here because I have some specific questions to them, including what is the current number of licensed adoption agencies? What is DRT's eligibility requirements for the licensure of adoption agencies? And what are the authorities of adoption agencies upon licensure? All right, so we'll begin, I guess, with questioning now for this panel. Again, thank you for being here. I guess for public health then, Ms. Uggan, are child placement agencies currently applying for licensure through are they currently approved through the department in any form?
Not at this point in time.
Are they currently acting in placements or screening of adoptive homes?
Perfect. Ms. Moiko, who oversees the Human Evaluation and Placement Services section, would be able to provide an answer for you.
Good morning. So there is an adoption agency currently on the island who is licensed through the Department of Public Health and Social Services. Since in June, we received 2 adoption study report via this adoption agency. And in this adoption agency, through the court, asking our agency to acknowledge and solidify the report that was given to this adoption agency, my staff worked collaboratively to ensure that all the information that was provided was in their home study. So what happens is when the Bureau of Social Services receives a court order adoption from Superior Court, I would assign it to one of my social workers to conduct the adoption study. Knowing that it came from this particular adoption agency, they received the GAR on how adoption report is written and submitted into the Superior Court. So they followed those directions. My staff would re-interview the parties involved in the adoption to ensure that every information was accurate and is acknowledged at the end of the report from myself and from our administrator and the social worker before we file it through Superior Court.
So is it filed in your name in the Superior Court, the Department of Public Health's name?
The court, it's filed under public health.
Okay. All right. I have some other questions. A lot of them are technical regarding the rules themselves, and I'd like to, I'll just hold off on those until I allow my colleagues to ask some questions. I'm going to begin with the Vice Speaker. Vice Speaker?
Situ Asmasi, Madam Speaker, for giving me the opportunity to speak first. I just want to make a statement, Madam Speaker, and then thank the panel for being here this morning, but also to Brittany for your help and what you've done in the community as it relates to foster care. And Madam Speaker, you know, as the co-sponsor of the public law 3668, which was done this year, right? With Senator Mary as the author, I just want to thank Public Health for submitting these rules and literally taking the time to work on it. So I want to acknowledge the work that you do also, and of course your new position as the Speaker noted. But one of my concerns upon the review of the rules was the definition of a child placement agency. And as you all know, the laws were very clear to recognize any individual or agency that is involved in the placement of a child for foster care, therapeutic foster care, or adoption. I believe, I want to note it, I know she's sitting right next to me, that Senator Torres recognized that the foster care system is overwhelmed with our island's most vulnerable children, and that is why we wanted to ensure that anyone involved with their placement who was not a CPS worker, and I hope I'm saying this right, will also, is also licensed, right? So the rules that you submitted did not include those agencies, so unfortunately, after it's submitted, it could not be revised until committee. So I want to say that, I hope to say that I'm glad to hear that you will be working with the committee to correct that error for the safety of all our children. And I'm going to note, as I see Brittany here, and as I see Public Health here, and as I know that there are folks out there who literally really want to help and support at least having those children who are not as fortunate, but to try and put them into a good home, to try and give them the best possible care. I can say that sincerely as one who's had to work closely with families who needed to go into an adoption and be with a family who's loving and nurturing, and having to work with nonprofit organizations who continue to try their very best to help, and that need for more help. I want to be able to say that we're going to continue to work together. So I guess based on the statement that I said, are there any added inclusions that you want, or do you share with my same statement that should all be included? So Cassandra or Britt, I guess yield to both of you.
Thank you. I hope I... Yes,
I'm
that's
sorry.
okay. I'm Bethany Taylor. No worries. So I'm actually very concerned with the rules and regulations being a part of our organization. I want our nonprofit to be as a bridge and a help and support to CPS as much as we have, and I want to continue that relationship because it's vital to our island. I don't see how these rules and regulations would need to affect us. We are not, I want to just be very clear in why, though, so that we can maybe address this. So our organization does not place children.
Okay.
But we do recruit the foster family. We have an informational meeting once a month. I also sit one-on-one, do informational meetings with prospective foster families that are interested in fostering. And with that, CPS, a social worker, usually Mayfei, is always present at our informational meetings once a month. So CPS is always in collaboration with what we do. We also, on our website, make it very clear on how to obtain an application on how to foster. We also give applications out at our organization. We also facilitate helping them if they have questions on how to fill out the application. We'll assist in any way possible. Then we will tell them, once everything is completed, you go to the Terlaje building and you turn in all of your documents to Sarah Senor, the licensing social worker at Child Protective Services, who then actually licensed that foster family, approves their documentation, and makes sure all the background checks, everything is acceptable for that foster parent to actually be a foster parent. With their approval and their licensing to that child or to that foster parent, we then, I don't want to use the word facilitate, we then help saying, okay, all these families, they were coming to our informational meeting, they have been helped by Harvest House, you have now licensed them, so now they are approved listing of families. Now how can we support them? So we don't actually, even with Child Protective Services has 3 children that need to be placed this week, we may say, we have these families that are very interested, they have shown interest, they've turned in, or they've accepted an application, they're turning in an application with you, how can we help? We're not actually placing the child there, so CPS with their committee, they actually say, okay, we have this 2-year-old, we're gonna place with the Taylor family, they're the licensed foster family. They're gonna do the placement, then they're gonna come and get the support they need at our organization, Harvest House. Did that clarify what we do and how I don't feel like it's an agency that needs to be a part of an adoption agency or rules and regulations because it's different? Did I clarify that for you?
Yeah, well, I just wanted to make sure then that the clarification is there, and I really appreciate you being here to share that perspective. And Public Health, do you have anything to add or share?
Thank you. I just want to bring up to the legislature that there are rules and regulations for foster families that have already been created and that we've been utilizing for many, many years. It's Public Law 23-143, and it says everything on how to become a foster family, the licensure, what it entails, and so forth. We collaboratively work closely with Harvest House. We have a great process on recruiting and ensuring that all the foster homes we license are safe and able to help all our children. And we've worked closely for many years.
We would also like to concur with Bethany that the focus of this, of course, is for adoption agencies. And gosh, I really have to give kudos to Bethany. She's there every hour of the night when we're calling her for placement for these children that we've exerted over. So I too concur with that. There is a distinct difference between that of finding foster placements and that of adoption agencies.
Thank you. Thank you, Madam Speaker, for me to ask this question. I also want to just note that for me personally, I'm not saying that there was, that they need to be the same level of requirements, but that they should be licensed also. And I guess for me, it's about checks and balances, right? So I just want to make sure that if we look at these rules and regulations, if there's things to make it easier for us to go through that process, or at least the clarification is there that we include all checks and balances and not take away from what's already out there, what's noted since the 23rd Guam legislature, but more importantly, what can we do to make it more accommodating, especially for those that need to go through the process. So that was where my personal take was. So, Madam Speaker, thank you for giving me that opportunity to inquire and at least get the clarification out there, and hope that we can continue to work the checks and balances. Sitos Masi.
Situs Masi, Vice Speaker. If I could just insert in here. So public health, can you just clarify, do you see that any part of these rules affect foster placement or foster rules, your existing foster rules?
At this point in time, I don't see, because we already have a series of regulations regarding foster care in itself. I don't think so at this point in time.
All right, and also could you just describe, it's my understanding that public health worked together with maybe a national group or some other, did you receive any assistance in drafting these rules and regulations, or are they patterned after any other jurisdiction?
Yes, so public health worked with our federal partners with the technical assistance in creating these rules and regulations. We've mimicked the Arizona adoption rules and regulations. We looked at many. Every state, 50 states, they require just as much of the policies and procedures and regulations and rules as what we've submitted in our draft presentations to the legislature.
Okay, thank you. All right, Senator Rigel, questions or comments for the panel?
Yes, for public health, there is written testimony here from Ohala Adoptions, and in their written testimony, they do feel that, I guess, they call it an exhaustive list of regulations that require intense implementation practices and maintenance, and they think it's unwise. In their testimony, they also cited, they cited the state of Missouri. So they attached in their testimony the licensing requirements used in the state of Missouri, which are required by applicants seeking licensure. And I guess they believe that in the state of Missouri, that the licensing requirements are, quote, realistic and ethical for everyone involved in placement practices. Did you guys have an opportunity to review any of the regulations in Missouri, and is that something you're familiar with? And what is your response to some of Ohala's concerns?
I think for any agency, right, that would be of concern. I did not personally review Missouri's regulations. However, for example, Arizona, we did review that, and we just felt that in terms of our needs, that was more appropriate. In the end, it's really to safeguard, all our children. And if there is anything in regards to modifying or amending such regulations, we're open to that as well. We're open to collaborating with that, to hear their concerns or what they may be, and move forward from that. So although these are, submitted, we do recognize that in the end that we may be amending some processes and some rules and regulations.
Okay, thank you.
Thank you, Senator Rigel. Senator Taitzikui.
Thank you, Madam Speaker. And first, I really want to commend public health, and I know, Mayfei, you had a hand on this. And for the listening audience, it was so thorough. People of Guam can rest assured that these rules and regulations are set in place to protect our most vulnerable, our children of Guam who are seeking a home. So I really appreciate all the hard work you put in there. There were pages and pages of this. I mean, just the rules and regulations alone, about 38 pages long that I had. And then, of course, all the applications that were followed. I thoroughly looked through it. As you know, I have a great interest in protecting our children on this island and will continue to be an advocate for them. But Mayfei, the work you did on this was excellent, excellent work. There are a few things, nothing's perfect, and then we're trying to make it perfect. That's why we're here today. And there are some questions I do have with regards to this. And please, if you can bear with me, I'm still going on the interim rules that we recently received from Public Health. And I know that the interim rules was given to the legislature on June 24th, if I'm not mistaken. That was quite a while ago, but you know, the Speaker's office did not receive these rules until September 1st. So I don't know what the delay was. Are you aware of any kind of delay why the Speaker's office was not able to get these rules and regulations until 2 months later? Okay, that you don't have to. I just wanted to know if there was something on your end that might have delayed it getting to the Speaker, and there was nothing. So the delay happened on our side here, or on the Committee on Rules receiving this. So I just wish we could have, you know, looked at this sooner than later. So I apologize that it did not be, it was not addressed as soon as we got it. But I'd like to thank the Speaker. As soon as she received it, it was referred to her. She right away provided this public hearing for us to talk about these rules and regulations and even strengthen it, and maybe ask some question with regards to my biggest concern actually is the fee on page 9, where it talks about the fee and non-refundable initial applications for fee of $400, and renewals will be every 2 years at the fee of $250. Fee may be increased at an annual rate of 5%. And Public Health has estimated in 2021 that it would need about $52,305.80 for the salary and benefits of social worker 2 to monitor private adoption agencies, perform home visits, review adoption applications, and conduct inspections of private adoption agencies to ensure compliance with rules and regs. So my concern is recognizing this, do you propose the application fee would reflect an estimated department expense required to set up and sustain the required administrative staff and equipment and supplies? I mean, like you mentioned earlier, we only have one agency on this island, which I'm hoping will have to comply with all these guidelines to move forward with their business of adoption. So right now, does the Public Health have the funding to support this?
You know, I'm going to go with, of course, we're building, right? We're building capacity, and any funding that can be given to us at this point in time based on the new budget could help. You know, BOSA historically has really just found it within themselves to do what they need to. I can only assume maybe funding may have been a part of it. We know that staffing is an issue. So I can promise you that we will do everything in our power to make sure those studies are done and that the licensing is done appropriately and properly. However, I might have to admit that you know, staffing, personnel, we may have to revisit, only because it does take time for studies to occur. It does take time for interviews to occur, and visitations, and observations, and home studies. So to answer your question, I think we would like to revisit that in order to give you a more prepared number as to how much staff we would need and the funding that would be required to fund that staff.
Well, thank you so much for that. And I will look aggressively here on our side to try and find that funding for you because it's mostly needed. We already have an agency on this island, and without any rules and regulations or even monitoring at this point is a detriment to our community, to our children, our most vulnerable. It's not fair. So we need to find this funding. I hope that you can look aggressively on your end if there's any funding there, and then we'll do the same on our side as well. But it definitely needs to be so do you think that actually the funding that you require for the license, the fees, is that enough to cover that? Or is that something that other jurisdictions also have that type of fee structure or amount?
So when we created that amount, or when we identified that amount, we also looked at other, the child development centers. So they also have a licensing fee, and their fee is $200 every 2 years. So those are for our child development centers. They also need to be licensed with the Department of Public Health, and also with Revenue and Taxation. So we felt that, Public Health felt that 400 may be an amount that was given when we produced the draft rules and regulations.
Thank you, Mayfei, for that comparable. It does make sense. I see where you got that funding from, or that amount from. In section 16 on page 17, the training requirements on letter A child placement agency for the purpose of adoption shall provide initial and ongoing training for professional employees. One initial training shall include orientation to the child placement agency for the purpose of adoption and any other child placement agency for the purpose of adoption, and the department policies and procedures that are relevant to the employee's job. For the record, what training will be required of applicants and their employees with respect to the provisions of basic emergency medical care, language and cultural sensitivity, active shooter, and mental health services?
I think all training, relevant to the welfare of a child is really important, and that includes all that you have just mentioned. In our collaboration, in terms of the adoption rules and regulations, we're thinking more so of what training would be provided for the license, the person doing the licensing, the social worker who is able to conduct the studies and write the reports. I think more so our focus was on that. However, now we are here at this point in time and understanding that there may be additional training that's required for the personnel that we intend to bring on board to, deal directly with the adoption rules and regulations. So we won't have your answer right now. However, now we can think about what additional trainings will be required, such as emergency, health, and the other areas of training that you had mentioned. So we'll definitely go back, collaborate a little more, and provide you an answer for that.
There's a section in the adoption rules that talk about directors having, certain qualifications to be met. The employees, whether they're the receptionist at the front desk or a volunteer, is there somewhere in the rules and regulations that require them to take like first aid, being able to resuscitate a child, things like that?
In terms of the adoption rules and regulations, no. But I do know that, for example, in the child care setting, there is a requirement for at least, I believe, if I'm not mistaken, 2 personnel to be certified in first aid and CPR. So those are things that we can take a look at and we can possibly adopt and amend in our rules and regulations.
I think so as well. I mean, we require that sometimes at these daycare facilities, that they have the first aid and CPR for children, which is a different perspective from an adult for CPR. So maybe that's something, Madam Speaker, that can be incorporated with your blessing, of course, to include that requirement for anybody working at an adoption agency to have those qualifications. Thank you for that. The Public Health BOSA HIPS adoption unit may audit, and this is on page 28 if you're following along, makes it easier as we discuss this. So it's on page 28 where it says E, Public Health, BOSA, HIPS adoption unit may audit and designate a certified public accountant to audit an adoption agency's fee structure. The section provides that an audit may be sought by Public Health, recognizing the role that recognizing the role that bad characters may have in adoption services worldwide. Does the agency find it prudent to require regular review of private adoption agencies' financials? It says may here, that's why you say may, and I'm just thinking it's something that should be very important because this is what we're all worried about. I mean, the elephant in the room is human trafficking, right? And money being exchanged, in order to be first on the list, or, people coming to these agencies.
So we did discuss that. We did discuss, for example, what are the fees that these adoption agencies may charge? And we did talk about trafficking. And because we were unsure about that, I believe that is why we had indicated that we may do that. And the reason is because, for example, in our current capacity, if we receive a study from an adoption agency, it is our HEPS unit who goes and validates this information, does the interviews, the re-interviews, possibly go out and do additional studies in the home and on the families. So we know that that occurs, right? But what we don't know is whether or not there were already fees that have been paid to the adoption agency to do that study. And, I do understand your sentiment, and I agree with your sentiment that we need to somehow regulate that.
I think that the may, I think the Public Health should,
Shall.
make that additional step and maybe incorporate shall.
Okay.
I mean, not shall. Yeah, shall instead
Shall
of may.
or will.
I'm sorry, shall do
Okay.
that. So with that, Madam Speaker, I ask that we also make that amendment into the rules and regulations, or that Public Health may consider that with your blessing. Because I
Duly
think it's very
noted.
important to be proactive.
Yes.
In page 30 of the rules and regulations, B, monitoring activities may include the following, and it has the announcement of one announced and one unannounced on-site inspection of the child placement agency for the purpose of adoption during the licensing year. To be clear, the proposed rules were required up to 2 on-site inspections every year, if I'm not mistaken, but are you limited? Will Public Health be limited to just 2, or do you have the ability to go in there throughout the year at any time without any excuse but to visit that?
We
to
do
visit?
monitor unannounced. We make unannounced visits.
Other than one time, because it says here you're already putting down a amount of time. You're limiting yourself to one time unannounced, one time announced. So I was wondering why that limitation is there for Public Health.
I think we can look at that and kind of like reword it to,
Or
make
more.
that the
Yeah.
minimum amount versus the actual amount that
Minimum,
we would do.
yes.
Correct.
I greatly appreciate that, if that
Okay.
can make that correction to give you the ability to go beyond just the 2, whether it's announced or unannounced, at the
Okay.
discretion of Public Health. That'd be greatly appreciated. Also on, there is on page 29, well, actually, it's not on 29. We already talked about the fees and agreements. This question is just, how do you monitor if an adoption agency receives donations that can actually be construed as something other than good intentions?
We don't have anything in place in terms of monitoring donations for adoption agencies at this point. If it's something you would like us to consider, of course, the team is more than willing and able to go ahead and take that into consideration.
I think it would be very, very important to be able to do that. I know the financials have something in there in place, but donations can be construed as something other than good intentions, as I mentioned. An example, a couple coming in and wanting to donate, $50,000, and then next thing you know, and a month later, they have a child who there is already a waiting list of other parents in line for adopting a child, but this group happened to become first in line all of a sudden. And lo and behold, there was a donation of $50,000 to that agency, that company. So there has to be a way to monitor these donations, especially if the agency is under the umbrella of a nonprofit organization, which I know they have to basically provide that information as a nonprofit organization. But I think public health should keep a keen eye on things like that, moving forward.
Okay.
On page 21, you talk about the requirement of the agency of insurance coverage. In there, you don't have a minimum amount. As a former insurance agent, usually, there are certain certain businesses that require X amount, like a gun club would require more insurance than another area like a retail store. But there is usually a minimum amount. So I think that maybe if you can address the minimum amount, and probably a good area of expertise in that field, of course you deal with child care all the time, right now, but an insurance company could probably give you the standard amount of liability for an agency such as this. I mean, actually, if you think about it, you'd have to go to those other jurisdictions because we don't have an agency here on Guam, so probably another jurisdiction. But there should be at least a minimum amount, in all aspects of workman's comp versus general liability.
Okay.
So a minimum amount.
Okay.
Okay, and that's on page 21. Also on page 22 and 23, it talks about, or maybe before that, the documents and records, keeping records of adoptions from these agencies, these businesses on Guam that deal with adoption. And it says in your rules and regs that they are required to keep these on hand for, I believe, 99 years, if I'm not mistaken. Is the number correct? 99? I believe it's 99 years. I don't have it in front of me, but it says about 99 years to keep it. But in the event that they close their business, that they are responsible for turning over these records to the next adoption agency. If not, then it goes to public health. We want to make sure that those records, even if it's not turned over to another agency, but all records like this should be given to public health as a means of record-keeping purposes on a government perspective. So I'm not sure why or anything in the rules and regulation that requires records should be turned over to public health. Of course, in confidentiality, of course, and under lock and key, but later on down the line, if anything should happen or, the typhoon comes and they lose all their documentation, that there is a second option of being able to obtain these records. Because I do know you have in these rules and regulations all the other aspects of a child, their welfare, their mental state, their family background, things like that is all recorded. So it's good to have that kind of information. I particularly like on page 15, section 12, must employ a social worker. I greatly appreciate incorporating that. I think we can't just pull anybody off the streets to come and work in an area like this, such as this, and not have the background to assist, especially traumatized children. I know babies come in, but it's preferred to have babies, but some children are very traumatized, and it's good to have somebody. So I greatly appreciate that you incorporated that. On page 18, this is most especially, it does explain on page 18 where it talks about staffing ratios. Staffing ratios, and then it explains from A, it goes to B to determine what is sufficient before or the standard. Can you kind of explain to me, it still doesn't tell me what is considered the ratio on staffing for this area. So it is on page 18, the original rules and regs that were sent, not the corrected version. Can you kind of explain to me, how are you going to determine what is considered significant on staffing?
I believe this makes reference, if you look on C, I believe this makes reference to the caseload to the social worker. And so in the excess of 20 children. So we all know that in social work, right, we have a variety of cases, but what that does not reveal is the amount of children, you know, in those cases. We can have 2 cases, but it's actually involving 13 children. And so with this one, I believe the staffing ratio was made reference to the caseload for the social worker. However, if, you know, we're looking at a child placing agency, if that's what your concern is, we do have the Bureau of Child Care Services, which identifies ratios per age, you know, within the grouping and age grouping. So for example, infants is a 1-to-4 ratio, which is 1 worker to 4 children. So that's something we can consider, and we can go ahead and duly note, and we can get back to you.
Okay, thank you for that. I just have one more, Madam Speaker. Thank you for indulging me in this. And page 27, it talks about 1,000. Let me get to that part here because I know this one was interesting. This is the birth parent service agreement prohibition. On number 2, it says, contain an explanation in plan language describing any monies that an adoption parent may pay to birth parent, including that a birth parent may only receive payment up to $1,000 without court approval. I find this interesting. Can you explain this scenario here? I mean, any kind of money being exchanged, again, my biggest concern is, you know, the trafficking and money passing hands. And you have a lot of desperate people out there right now who'll unfortunately sell anything. And this is something that we have to be very conscious of. So can you explain to me number 2?
I believe that that was in reference to the fees being received, and we put down 1,000 for the purpose of. I didn't think that was a lot of money. You know, I mean, just like for bingo, when you go in, tax purposes. I was thinking of tax. I mean, what's an amount that could be put in there, but we could always make it subject to change.
I can see your concern.
Well, yeah,
I can see your concern with that, right?
If you read it, let me read it for the
Yes.
record, okay? It says, contain an explanation in plain language describing any monies that an adoptive parent may pay to a birth parent, including that a birth parent may only receive payments up to $1,000 without a court approval.
Yes,
So-
I can see that.
Okay,
I
so
can hear that.
Anytime you do anything like that, whether it's $1 or 25 cents, it should all be recorded. It all should be accounted for, especially dealing with something like this. So please review this section here.
Definitely.
Revise it to find there's no improprieties at all that's going to be allowed by anyone, you know, coming into this situation. Okay? And thank you, Madam Speaker, for the opportunity to go over these. I'm sure there's a couple more, but it's something that I just leave with the Speaker at this time. Thank you.
Thank you very much, Senator Teitzke. And I welcome any other additional questions that you'd like after this hearing, and we will also forward those to Public Health. And I thank you for your willingness to review some of these areas and provide additional feedback. Thank you. Senator Ada?
I have no questions. I'd just like to thank the panel for being here today and giving us an update on these rules and regulations. Thank you, Madam Chair.
Thank you, Senator. Senator Torres?
Thank you, Madam Chair. I'd like to thank Public Health and you, Ms. Uggan and Ms. Muko, for putting these very important rules together. I'm also glad that Public Health has acknowledged the need to revise the rules so that they're wholly compliant with Public Law 3668, which is what prompted Bill 334-36. Currently, these draft interim rules only apply to child placement agencies for purposes of adoption, and it excludes the child placement agencies for foster care and therapeutic foster care. On page 2 of your interim rules, under the applicability section, it reads that these rules and regulations are applicable to child placement agencies for the purpose of adoption licenses for the purpose of adoption. However, the law states that child placement agencies shall mean any person that is not licensed to practice law in Guam, corporation, partnership, voluntary association, or other entity or identifiable group of entities, whether established for profit or otherwise, aside from Child Protective Services that places, plans for, or assists in the placement of any unrelated minor for care in a foster care home, in a foster home, a therapeutic foster home, or an adoptive home. And the draft rules as submitted and currently written operate on a much narrower definition other than the one provided in Public Law 3668. You mentioned that you were going to include foster care and therapeutic. Will these rules be, additions to the rules be submitted before the bill is reported out of committee? Is that your intention?
That is our intention.
Okay. Thank you. I want to circle back, after listening, Ms. Taylor, to your testimony, I want to circle back to the whole premise for why foster care agencies and others were included in this bill, and that we advocated for licensure of them. And I'm going to read Ms. Bethany Taylor from the public hearing on Bill 206, which you testified. And you stated very passionately that, as for Harvest House, this bill also puts checks and balances on us as a nonprofit to have rules and regulations in our efforts in helping and coming alongside CPS and your valiant efforts in getting homes for these children, whether they are foster care or adoptive homes. And you concluded your testimony by stating that every child matters to us, and it will take all of us, private entities and nonprofits, individuals, senators alike, all of us here in the government agencies, to come alongside each other and to find homes for children that are vulnerable. And I'm here to speak out for them, and I'm also in favor of Bill 206-36LS. And Bethany, we are always thankful and very grateful for the incredible work of Harvest House and for your personal devotion to our children and to your faith. And I'm also especially grateful that you recognize this need to include everybody. The bill also went further to require individuals that plan for, or assist in the placement of children in adoptive homes, and that they must also be licensed. And this, I just want to remind Public Health, was out of concern for those who were fearful of fraud and abuse. And that was why the language was brought in to include other than just adoptive agencies. And I'm going to quote also from Bill 206 public hearing, where Deputy Director Uggan Terry himself confirmed at the public hearing that most adoptions on Guam are private adoptions, which are not under the purview of Child Protective Services. And what especially caught our attention and concern, and why Bill 206, which became Public Law 36-68, which is now the provided for the requirement of these rules to be developed. Mr. Uggan stated that these women who give birth, who say they have somebody in mind for their child, and it's through this process that excludes us here at Public Health. they've identified whoever the family is going to be. Often these families that they've known for a period of time, and this has been the traditional practice here on island. But then he adds, now here lately, it seems like there are other adoptions taking place at the level of the hospitals, in which case perhaps the mom doesn't know this family as well, and she really doesn't know exactly what the placement of their child is going to look like. And so it's these adoptions, the ones that Director Uggan stated are the traditional practice on Guam, are between individuals or private families. But the outcry is for the safety of all the children, private adoptions and the other that Terry Uggan described. And so by all means, public health should create rules, and they are empowered to do so, and to execute oversight and regulatory authority for child welfare. But if we are actually concerned about protecting our most vulnerable, we would apply requirements to everyone involved in placement, not just the agencies that can only be chosen by public health to begin with. But I make that statement and I bring us back to that whole idea of why 9 senators voted for Bill 206, which became public law, which then required us to have these interim rules. I do fear, however, and I would concur, as it was brought up by Senator Rigel, that perhaps in my initial read of this, the requirements, the qualifications, the background information, and the personnel records of staff are quite burdensome. And I fear quite burdensome for Guam standards and the true climate of Guam and the availability of people that are qualified and educated to fulfill these positions sufficiently, whether they are at nonprofits or in foster care or the individuals themselves who place the children. I wonder, in making that statement, do these requirements in your interim rules even have parity with the requirements of Child Protective Services staff? Are what we are expecting of nonprofits equal to what you expect within your own staffing pattern?
Yes. The social workers' requirements are the same requirements that the Department of Administration requires social workers to fall under and be qualified and rated. So these standards, these are actually minimum standards. When we looked at other Arizona State, for example, they required a much more, more intense. For more years of services, having a master's degree, and so forth. So I followed public health followed the standards of a social worker's requirements with the Department of Administration.
So all your social workers have master's degrees, for example?
No, what I said is, we follow the standards and the qualifications with the requirements of a social worker under the Department of Administration. Most of the state, or the state that we follow this from, their requirements are a much higher standard. They required master's degree and doctorates.
Okay.
And we did not put that in. We made it the minimum standards on what is also how we are qualified for our positions.
My thoughts on the interim rules is, I can understand the models that you had, and that there are also other models that have exemptions for in place of there are other trainings or certifications or experiences that can equate to that, and I think that might be necessary. But what I'm most concerned about really is that if we're truly If the whole premise was to have a set of rules that everyone can be guided through, because we know that ultimately Child Protective Services is the catch-all for overseeing and regulating even the adoption agencies on Guam, and that you have audit powers and all of that. So that is understood. But where we are going to branch off now to say that nurse who facilitates adoptions or a doctor that facilitates those private adoptions, or even Harvest House who assists in identifying potential adoptive families, that there should be a baseline set of rules that are not overbearing, that don't prohibit them from operating, because we understand that the challenges of, say, foster care, the challenges of recruiting foster parents, foster homes, people interested in assisting with the crisis of displaced children on Guam, and assisting CPS, most especially, in addressing this. A lot of it is volunteers or people that may not have been schooled or gotten degrees in their specific social sciences areas, but who are otherwise qualified to work at or facilitate. And I think that there has to be, just practically on Guam, there has to be a sensible way of establishing rules so that everybody's on the same playing field, that CPS is indeed the catch-all and is in charge of the placement of children, that all of that happens, but within reason, because I do feel, in all sincerity, that the requirements may prohibit people from actually operating sufficiently or meeting the standards required for licensure. And that's the one thing that I caution, because this is the first go around at this. And so, of course, in every endeavor, we grow into it. You know, we have our ideal, but there are steps towards how we attain that ideal. And it could be a baseline requirement that then could be, once we've all established that baseline and we're operating fine, we can continue to strengthen as needed, as if and when problems or areas of concern present themselves. So that would be my only caution with this, is I look forward to the addition to the interim rules that includes others such as foster care or any individual that assists in the placement, but that we also address from the adoption agency just looking at what is an impractical set of standards for Guam, for nonprofits, and perhaps, Ms. Taylor, this may apply to you as well in your operations at Harvest House, and you know, whether in fact you can have the required staffing at the required education levels that are prescribed. And that's all I'm saying, is that we need to be reasonable, because if we can't enable people to come into the fold and help, we're not making any progress. But if we can enable people at a baseline where it's safe, regulations are in place, rules are in place, everybody is on board, they're under your direct supervision, under your radar, under your audit authority, I think that's the first place we need to be. And that's where I would like to offer and help you, Ms. Sagan and Ms. Muiko, and your staff to perhaps find that balance that would then allow, as Bethany Taylor so passionately testified in Bill 206, when we were all worried about what is the adoption scenario on Guam. Is it mostly through CPS, or is it mostly private? And we found out through testimony from public health that it was mostly private, but that there was this other caveat to private that didn't involve a mother and an attorney, that involved healthcare providers with maybe not strangers to the healthcare provider, but strangers to the adoptive parent, which is really not the way it usually goes with private adoptions. It's usually a known consent. And so those are the things that, looking at Guam and what Guam has to offer and what are our limits because of our population, because of our the amount of social workers we have available, with certain degrees in education and training. That has to be how we address this. And so, Madam Chair, I hope that, Ms. Duggan, was I clear? I hope
Yes.
that I was clear.
We'll definitely take that under advisement, and we'll reach out to you when it comes time to kind of like iron those concerns out, if that's okay with you.
I would hope so, because in all the bills that have preceded this, it has always gone back to that desire to assist public health. How could we assist public health through policy? How could we assist Child Protective Services through policy? How do we take into considerations the efforts of Harvest House and all those attorneys, not attorneys, but all those other people who are interested in placing displaced children into adoptive homes. And so that's all that we've ever tried to do. So in that effort, and going forward with Bill 334, that would also be my concern. It's just, how do we marry it so that indeed this is a good Guam model, not a model based on Arizona or modified from Missouri, but a true Guam model that fits the profile of Guam and the needs of Guam. So, Sidzuas Maasi,
Yes.
Madam Chair, and Bethany, I don't know if you had something to add.
I would like to add something to that. Thank you for bringing those things up. I would like to address two things as what you said. One, these rules and regulations state Guam Child Placing Agency rules and regulations for the purpose of adoption. And throughout the whole thing, it says that every time. So we need to clarify if we are going to have rules and regulations for adoption agencies, and this is what that is, or we are having rules and regulations for placing agency rules and regulations for the for Guam Child Placing Agencies. That is different than adding for the purpose of adoption. So to me, I love how you quoted me. I am very passionate about the adoption process on Guam. I really am. I personally have done this. I'm going to be doing it 6 times. It's a lot. And I personally have witnessed so many adoptions on Guam. And just so you know, Harvest House, I think we've seen 13 adoptions happen since January to now. That's a lot of adoptions, and I'm not saying we do it. We don't do anything. We are only the placement of assisting. So when you're reading that definition, we would be in that part of assisting CPS. We do. We help them find these families. So I personally want clarification on if we are doing, like they also mentioned, Department of Public Health mentioned therapeutic foster parenting, foster parents, and adoption parents. They're all 3 different. So we also are assisting them in trying to find therapeutic licensing foster families and assisting them in finding foster families. So there is no way with these rules and regulations presented today, Harvest House is going to be able to meet these regulations. I will tell you that now. And I will tell you we do exceptional work, and that you'd be fine with auditing us, and we are exceptional. We will do our very best in doing this, but we would not be able to meet these rules and regulations. For one, many of them don't even apply to us and what we do. But I think going forward with meeting you of how are we doing the private sector? How are we handling the nurses at GMH in that situation? How are we handling the private doctor? And how are we handling foster care and therapeutic fostering? And how are we handling adoption agencies? To me, if you are going to do rules and regulations, which I am fine with, they all need to be separated because they're different agencies, they're different sectors in how to meet the need. So I don't know if I answer questions, but I just wanted to clarify that for everyone, if that helps.
So we do take into consideration, I mean, we're also not here to make things much harder than they need to be. We want to find homes for those who are vulnerable, and we want to find them as swiftly as possible in order to provide that stabilization. Now, these are all concerns that, based on the rules and regulations that have been presented today, have surfaced, and we're very amenable to going back to it. And these are awesome, recommendations, and there are things to really think through. And we will go back with our team, and we'll take that under advisement.
Listen, I just want to also, I totally understand both, and that's the whole idea, is that everyone facilitates in the adoption process. And where it involves CPS, those people are facilitating. The only time that you don't, is in the private adoptions where they're not subject to home studies, I believe, and all of that. So in some ways, it's the same sort of consideration, the rules and regs, but like I said, it has to be practical and it has to be doable. Otherwise, you can't operate. And that's my concern, is how do we ensure that you and the adoption agencies, which you similarly are facilitating the placement of children, that you're enabled to go forward and that CPS has the rules and regs in the audit capacity. So, Stu Masi, thank you. Thank you, Madam Chair.
Thank you, Senator. I'm going to follow up now with some of my questions. So first of all, I just attended a human trafficking forum. Maybe some of you were there. It was maybe 1 week or 2 weeks ago, and they reiterated that Guam is high risk for human trafficking of children, women especially. They even cited the incidences rising of men. And I also reviewed the rules, and as I asked earlier, it looks to me like these rules are very much centered solely on agencies that are going to be licensed for placement for the purpose of adoption. And I know that you also govern other placements, but for the purpose of adoption, that's what these rules are for. And that's why we tried to clarify that in the beginning. And that you do have existing rules regarding placement of foster children, and that you are going to also review those rules and submit additional rules for other types of placements. For right now, though, we have no rules governing the licensing of agencies who are very much, as in the laws I cited, very much involved in the placement for purposes of adoption. Right? And so I want to clarify. So for me, that's why I put this on as a priority, because in the absence of rules, such as the rules that govern foster placement, we have none. And so I would like those to be in place so that what CPS is required to do, and that's a minimum for what other agencies are also required to do who have similar powers now that have been extended to those agencies. There are other places, like you said, that are stricter, right? And I've seen some regarding, so the social worker component is really just a component for, if you're agencies must hire a social worker that is qualified, licensed on Guam, and you have to have a degree in social work to be called a social worker. And but I've seen other places where they have FBI background check, drug tests, interview with head psychiatrist, other requirements. Then they also have these rules require employees of an agency, these adoption agencies, pass a CAN, Child Abuse and Neglect Registry check. Can you just describe what that is and what that's for?
So the Child Abuse and Neglect Registry check is a check and balance for anyone applying to work in any who wants to work in a daycare, become foster parents, to go through our office, just like a police clearance and court clearance. If any referrals were made on them, the Bureau of Social Services conducts a child abuse and neglect registry check using our Cardex and our PH Pro background. It is also required with the Adam Walsh background check we work with all states. So if an individual has not lived on this island for 5 years, they will have to contact whatever state they are living in, such as California or Washington, D.C., and also complete a CAN background check. In the event that they may have lived in Europe or wherever, and most of the individuals who have applied in our office have been from the military. We have a relationship with the Navy and with Anderson to conduct a background check beyond the 5 years to ensure that people applying to become foster parents or working in child development centers are cleared.
All right, thank you. And, okay, so according to page 5 of the rules, section 01, capital B2, it states that licensed child placement agencies may perform a list of adoption services to include, number 2 is accepting a birth parent's relinquishment of parental rights or consent to adoption. So we know that, under another statute, 4309 of 19 GCA, a judicial decree is required for the termination of a parent-child relationship. But accepting these relinquishment of parental rights or consents to adoption, are you comfortable or do you have any concerns with this type of relinquishment or documents being signed without the Department of Public Health's direct involvement or communication with those parties?
I see that's an area that we can also look into and we can clarify further.
Thank you. All right, and we talked about fees. My colleague pointed out the fees. And these are fees that public health is going to charge, licensing fees or application fees, right? So, and the application fees are stated as, according to your rules, the non-refundable $400, renewals every 2 years at the fee of $225. Fees may increase at an annual rate of 5%. Will these fees go back to the Division of Children's Wellness? Is that what is anticipated?
Yes, that's our intent.
And all right, and so we just received, as we were speaking, they just handed out to us the BBMR's projection of financial impact from this bill. And so they talk about this, the impact is estimated by public health to be 187,000 plus in salaries and benefits, and that public health has stated there are 3 preliminary positions essential to the implementation of this. And so this is for personnel to screen the license applications, and so do you find that to be a reasonable estimate? And without these, again, there would be no screening, right? So maybe you could just explain why do we need 3 personnel? And what are they going to do?
So 3 personnel, if one is to monitor this adoption agency to look at records and ensure that staff and their facility is following the rules and regulation and unannounced visits and so forth. That would be for one, and to monitor and into compliance. And we also need a staff to ensure that their studies are true and accurate. Adoption studies is intensive. It takes a lot of work, and to follow up and to verify and confirm that everything is also true and accurate to ensure the safety that things have been done accordingly.
If I may expound, I think Furthermore, that we based that premise on our current calculation of employees who are doing the licensure for our fosters. So we have a social worker 3, for example, who will do the studies. We have administrative, and then we have the licensor. So I think that is why we had that additional 3 personnel in the event we were to proceed.
Okay, so you currently have this type of setup for foster, and they are dedicated strictly to that?
That is correct.
All right, thank you. All right, and Section 4 of the rules address denial of a license upon application or renewal. It states that the adoption unit may deny a license for the following, and then it makes a list, A, B, C, D, E. But this is a may, okay? So my question is going to be, why not a shall? And because, yeah, when can these kind of violations be allowed? So the list of violations where you may deny a license but are not required to deny a license are as follows. A child placement agency for the purpose of adoption had a license revoked by any state or foreign country. Applicant that employs personnel whose fingerprint background check shows that employee has been convicted of or is awaiting trial on an offense. Applicant does not comply with one or more of the standards listed in subsection C. For the purpose of an applicant that has intentionally or recklessly jeopardized the well-being of its client. Applicant that has a history or pattern of violations of applicable adoption statute or rules. So those are what you may deny an application based on those things, but I guess my question is, should we change that may to shall, you think? Yes, you're shaking your heads, yes? Okay. All right, and then we talked, my other colleague talked about audits that are allowed by public health is allowed to audit these agencies. And then we talked about fees that the agencies might charge, and so there's a rule that says the fees should be reasonable, right? Shall not charge a client more than a reasonable fee for services. So a child placement agency for purpose of adoption shall not charge a client more than a reasonable fee for service. If you could please just take a look. I don't see how reasonable is defined or determined, and if you have guidelines that you are going to use to determine whether the fee is reasonable. So I looked at some other places, and it looks like the states vary, but I've seen a range from $20,000 to $45,000 according to the Child Welfare Information Gateway. So I want to know how you will determine what is reasonable for Guam. And if we could more further specify that, I would like to.
We'll take a look at that and we'll further specify.
Okay, thank you. And then on section 29 of the proposed rules and regs, it talks about birth parent service agreement prohibitions. And it says that the child placement agency for the purpose of adoption shall advise the birth mother of her obligations. And before she enters into an agreement, right? That her child can be adopted. Do you have any concerns regarding that? I guess, so it looks to me like it's the same agency that is looking for the adoptive parent that is also advising the birth parent as to their obligations or rights, I would think.
Birth parents should also be made comfortable that that an adoption agency is overseen by public health, that public health could come in at any time if they may have a problem with the adoption agency. We're there to ensure that things are followed. I mean, public health, adoption, child placing agency should let birth parents know that they're also being monitored, that they're providing the best service they can to the family, to the mom.
All right. Do you have any concern with birth parents, like knowing their rights or being under pressure, I guess?
Well, with birth parents and with adoptions, they are counseled that their parental rights will be terminated. So they need to know that once the adoption goes through, their parental rights will be terminated.
So I think it's more to just ensure that they are comfortable with the decision that they make and they understand what the consequences may be and what it is that they will eventually go through. We can look at rewording that section and kind of like discussing that further.
Yeah, because I definitely agree that they should be counseled. Absolutely, they should. I just want it to be clear to us
Yes.
that these are, free from duress or any other pressure or enticement.
Thank you.
All right. Okay, so then maybe part of the confusion is attached to these rules. There are rules. These are rules and regs we're adopting with exhibits attached, including forms that Public Health has come up with, the application form itself. And then there are some others, such as exhibits D, E, F, I, J, M, and N, which refer to the word foster in them. They look to be the rules that you are already using for foster and that you want to, I'm guessing here, why are those relevant? Those were also sent in the interim package. Are you intending to come up with a document that kind of mirrors these forms and guidelines for placement of adoptions?
I believe so, yes.
Okay. Are we going to be able to do that then? So it's pretty much, you think that you want to use the same similar guidelines, the same forms, a lot of these are like background information, autobiography forms.
Correct.
That you use for foster parents, and you want to put these in, I'm sure, for adoptive parents?
Yes.
Okay, so are you going to be able to help us to make those changes?
Most definitely,
All right,
yes.
thank you. And I'd like to provide those changes as well to my colleagues. All right. Okay, well, I'm going to thank you then. I don't have any further questions for today, but thank you for all your work on this. I know that you were really under a strict timeline and that you complied with it, and I want to thank you for that, and that you worked very hard on it. I know because I called for other reasons, and they were saying you were very busy on this project of getting these rules and regulations done, and so I want to thank you for that. I think it is a very urgent matter. I think if we are going to allow adoption agencies, that they should be licensed, and they should be licensed under the purview of public health, and that they should follow strict guidelines. And so thank you again for your work, and I'm wishing you the best on your continued work in this field, and of course our children's wellness services. Okay,
thank you for taking the time to review this, because it really helps. Sometimes a new set of eyes is very critical to ensuring that the product is perfected. Thank you.
Thank you.
Thank you.
There being no additional individuals to present further testimony, the committee will consider Bill 334-36 COR duly heard. The committee will remain open for the submission of additional written testimony for the next 5 working days following this hearing. Testimony can be sent via email to Senator Terlaje @gmail.com or hand-delivered to my office at the Guam Congress Building. This public hearing is now adjourned. It is 12:10. Situs Masi.